I'd like to welcome everyone here to the second water forum put on by the Grange. For those of you that don't know anything about Granges, we've been around for about 100 years. We try and inform the public about controversial issues so everybody can make informed decisions. Our most recent battle at the state legislature was a top 2 primary, which we happened to win. We're proud of that. This is the second forum in a series of 4. The next one will be on June 14th at the City Library from 9:30 to 11:30. So June 14th, Saturday, from 9:30 to 11:30. And that's going to be on water resource planning, past, present, and future. So you'll hear a lot about the Wire Planning Unit while you're there. I'd like to thank Jack Lau, the county exec, for coming, and Barbara Brenner on the county council is here. Thank you. Steve Zilch is around from the Public Utility District Number 1, and Roger Brown is here, of course, on our panel. So have I missed any of the people that are? Mayor Ferndale, Mr. Jimson back there. Thank you, sir, for showing up. What'd you say, Garrett? Luann Van Werven. Oh, yes. Luann is running for Jason Overstreet's position for state senate. Thank you for coming, Luann. You're state rep. That's right. Mr. Doug Erickson is the senator. Yeah, us guys from the 40th, we make those mistakes about the 42nd. Okay. Without any further ado, a lot of you know our moderator, George Boggs, who is director of the Conservation District. Maybe you didn't know that he used to be a rice farmer in the southern state of California. And he also has a big boat parked at the harbor. Maybe he'll tell you how long it is. So without any further ado, we'll have George come up and start the moderation. Thank you.
All right. Oh, thank you, Larry. Thank you. We'll get used to this microphone and hopefully you won't blow your ears out. I would like to introduce right off the bat Warren. He's going to talk to you a little bit about this facility and ask your assistance.
Thank you, George. For those who've never been in this hall before, restrooms are behind the stage and they're accessible through either door on either side. Please, no beverages or food up on this floor. We rent to a number of dance groups and they really love this hardwood floor, but when it gets sticky, it's a mess. So please help us out with that. Thank you.
Thank you, Warren. Of course, that ties right into one of the ground rules of no tomatoes. Perfect. Thank you. For tonight, again, we've got a jam-packed session and we want to make sure that you all have time for your individual questions. So the format is that each of the speakers are going to have about 8 minutes to address 3 questions that were put to them earlier. After that, we're going to have Roger Brown and Bob Carmichael to come up and they're going to give you a PowerPoint with more information. Afterwards, we're going to have a short break just to catch our breath, and then we're going to go to a question and answer format whereby each of you will have an opportunity to ask a question. I'd like to keep it a short question, not go over a minute or more, and so we can give the opportunity to go through to the individuals, and if you know who you want to direct it to, let's direct it to them, and they'll have about 3 minutes. Given the number of people here, if we're short and concise, you should get your questions answered and so forth. Again, as the Grange said, this is a learning experience, and towards that end, they picked a diverse group of folks. And some of the things that may be said, and I don't know individually their particular perspectives, but you know, it may not agree with you. In fact, if the Grange did a good job in getting a diverse thing, you may outright disagree. But to facilitate the conversation and respect these individuals who are not candidates for a particular office or an axe to grind, but here to share, let's just treat their information. You can do what you want with it, file it away, but we'll work not to get in personal debates over the individual information. So let's have a great opportunity to have this exchange. It's community in action, and it's sure gratifying to me to see as many of you folks out here this evening to engage. So without any further ado, as they say, the first individual that's going to speak tonight is Chris Clark. He's an engineer for the Whatcom Conservation District. In addition to designing structures and developing nutrient management and energy conservation plans for large, complex livestock operations, he spent a considerable amount of time during high school, college years working on farms, whether it's a wheat farm in the east or dairy farms. He and his wife currently have livestock, some horses and some beef cows, and so he's going to offer up a perspective from the Cattlemen's Association. You want to come up here, Chris? Let me go here.
Sure, I can repeat that. So I joined the Cattlemen's Association a year ago, more or less to be able to speak at the meetings, but as a landowner in Whatcom County and also raising cattle all of my life, I wanted to bring a perspective both from the Conservation District to that association to help with technical problems, but also be able to share the information across the county, what's going on. Tonight I was asked to speak from Wes Kinch from the Cattlemen Association, and I took it on before I knew George was going to be the moderator, so he'll try to keep me straight on that. I do not represent the Conservation District tonight. I'm representing the Cattlemen's Association. I grew up in Cedar Woolley. I spent summers, a couple weeks out of the summer, coming up here on the Smith Road to my aunt's. I picked strawberries at a field that's less than a mile from the property I own now on Pole Road. I bought that property 6 years ago with my wife. It took me a lot of time to pick that property out because it had a water right with no ditches. I didn't have to worry about critical areas, didn't have to worry about water. Pole Road Association has a drinking well right adjacent to that property, so last summer when my well had a problem, the first thing I'm thinking of is water. Where's that getting drawn from? Who's taking my water? It's a big issue, and tonight we're going to talk about some of these things. The first question is, what are the top 3 most important water resource issues for Whatcom County? And in my opinion, the first one is drainage. We have 40 to 100 inches of rain falling on the areas that we're working in the rural landscape. That rain has to go somewhere. Drainage can be controlled with subsurface drainage and water control structures, but also ditches to move that water around. There's a huge problem with water quality and everything else, but if that drainage can be helped by managing it with management of structures or of areas where that drains to, the pollution, the water quantity questions can go away or at least be handled. The soil holds a lot of that water, but if it's saturated because there isn't drainage, more water runs off or sheets off the very top of that soil into the ditches and ends up in the river faster, and can cause erosion and other problems that take both nutrients and manure with it. So again, getting drainage into the system built in and managed well, we can hold a buffer there in the soil that will take in those storm events and let the water percolate through the ground and back out into the waterways. Runoff is another huge concern. That again, the manure, fecal coliform, nutrients, there's these issues that are surrounded that can be tested for, but a lot of this is also an economic piece of farmers' position that they want to utilize those nutrients and be able to keep them on their field. They're not necessarily letting them run down the ditch to get rid of them. Most of the farmers recognize the value of their nitrogen, phosphorus, potassium that are included in that manure. Water rights is a big issue, more from the political side. There's a lot of government issues with that water right issue. When you go look at the water rights, they're available online. Anybody can look them up. When you start seeing what those water rights are out there, there's a lot of water rights that are substantial, but they are not being utilized to that full potential on those tracks. So there is water out there that has right. There is a lot of the political move with the use it or use it law. There's a lot of exempt wells coming into the system as more and more houses come in. So the question on water rights is who has a right, who doesn't. The infrastructure for water distribution, both in the urban or the small landowners for PUDs, is growing or being managed by individuals, but I think part of the whole problem is the communication amongst the different organizations to bring solutions to this problem. Another issue is efficiency of use and understanding when plants actually need it, when the soil needs it, and the recharge of the system. A lot of farmers end up watering too late into the season or start watering too late in the season after the soil's dried past a point where the water is the best use. If we can use that water earlier, we can actually keep the water in the system, we can utilize it better for plant growth, and we can actually not use it or need it into September when the actual flow in the river is lower. The second question was, how should ample supply of water for long-term growth in both urban and rural areas be provided for, so as to be fair to all land users? I spent a lot of money on my 10-acre, and it came with a water right. And I searched that out, I found that property, and I paid for it. There were a lot of more inexpensive properties around the county that could have bought maybe even more land, but without that drainage and water right and infrastructure in place, there weren't the same value to that. I think placing water rights or giving water rights to everyone automatically will diminish that value of my property, and that's frustrating for me, knowing that I have put that investment in front of my family and my enterprise. The total volume that's being used by a cow in a day for drinking water at 20 gallons per cow, if you do the equations, there's equations out there to come up with numbers. It depends on the temperature of the day. We were lucky to live in an area that's very cool, so we don't use as much water as you might see published for Arizona or someplace that has very high temperatures. We also utilize a lot of silage, which provides water to those cows as well. So the actual feed that we put into our cows helps us use less water going into those animals. That water use in a dairy situation may be added to by wash down water and other things, but the total water use for those animals is 30 to 40 gallons a day per cow. When you look at the sewer system on your septic system designed, that's a 65 gallon per day water going into that design of that system. In a municipality sewer system in town, that could be 100 to 175 gallons per day per person. So those cows are not using the water that everyone is so afraid of being used in that system compared to the human population of the city of Bellingham. There is problems, again, with knowing how much is right, how much is already allocated out there, and if there is more for, as those dairies expand or consolidate in different watersheds or maybe different uses. The last question is, what are the pros and cons for approaches? The outlined approaches were the North Linden Water Improvement Districts compared to the 4-mile project by Dory Belisle and now being led by Resources as two different ways of approaching water quality issues. And which model do I think offers the best or most feasible chance of making lasting substantial improvement of water quality? I think the WIDS, from being a local involvement group, having people come to those, being able to speak, is a pro. I think the tax issue with taxing my 5 acres, and that brings another tax to my docket that I have to pay, and do I get equal representation on that? That there's a big question, because of the larger landowners will have more representation. There's more meetings, you'll have to go to more meetings, and there's going to be disagreement between the different land uses. So there's some issues with that side of things. But again, the local involvement brings, again, groups like this to meetings. You could make your say and make a pitch for your side of things. The 10-mile issue or local involvement is well established with Dory's project that she worked with. When they went to the new system, they brought in the 10-mile group, and there's some local people involved in that. So there is a local representation on that board or group. but there's still questions from the outsiders coming in. And again, working with the landowners across the county and knowing that there is an outside group coming in and looking over people's shoulders, testing the water. There's major questions on whether they're using the right testing protocols or if they're trying to pick on certain areas because of a certain perspective. And my big question is, do you know your neighbor? Because a lot of folks don't know their neighbors. When I grew up in Cedar, I knew everyone, and I don't know if that was my being a little kid, I knew everyone, or now I live in an area where there's very few neighborhood contacts, and I think that that is a big challenge with all of these systems. But the main thing with, or my proposal is to have and I think that the drainage system, again, sheds light on this, but to have a ditch tender come into a system where there's your local person that you know that you can talk to have an idea of what's going on both with you, but also understanding that the neighbor, everyone is doing their part, or if there is a problem, it's been identified by someone people can actually talk to. I think part of the problem is a lot of folks don't want to go either to certain agencies or regulators because they're afraid of being in trouble. And I think to fix a problem, you do have to identify it first to fix it. And no one is really identifying some of these problems. They're just testing and saying there's something out there.
Thank you, Chris. And it's really tough to try and deal with those three broad questions in a very little bit of time. And certainly with the questions and answers, we'll be able to probe deeper into those subjects. So thank you very much for that. And it was nice to hear that there's actually some potential solutions out there for people to engage in. The next speaker is Kate Blystone. She's the program director with Resources for Sustainable Communities, where she oversees the organization's clean energy, clean water, and youth education programs. For most of her career, she has worked in land use and environmental planning and public engagement, including a few years at Whatcom County and several years in private consultings with firms across Washington State. She enjoys a master's degree in urban and regional planning and an emphasis in small town planning from Eastern Washington University. She grew up on a farm in Eastern Washington, raising beef, cattle, and grains, and first moved to Whatcom County in 1999 to attend Western. Please give Kate a hand.
So this is a hot room. I mean, both physically hot and the sound is reverberating. I hope everyone can hear okay. Yes, we have a thumbs up. So thank you for this opportunity, especially to the Rome Grange and the 10 Mile Grange. I have something important to share with you all. I am the result of a Grange marriage. My grandparents met and fell in love at the Moran Prairie Grange in 1938. And so I wouldn't be here if it weren't for the Granges. So that's either good or bad, depending on how you think about me. So I'm glad to be here to share what I know and what I believe, and I appreciate all of you attending tonight. How many of you heard the radio this morning, KGMI? There was an announcement about this, and I said it was really important that people show up because this affects everyone. It's not just about farms, it's not just about tribes, it's not just about private well owners, it's everybody. And so I'm glad to see this hot room is so full of people. As George mentioned, I'm program director at Resources for Sustainable Communities, and we have a 30-year history of water protection, waste reduction, and youth education here in Whatcom County. Most of you probably know us because of our North Sound Baykeeper program. And we do some patrols you might have heard about. But there's also a lot of other things we do too, including the 10 Mile Creek Project, which is a collaborative project that I'm going to tell you about a bit later. And we're also local leaders on water quality and stormwater education in this community. So that's all really in an effort to help people understand how what they do impacts water quality. That's what it's really about. And this year we started a new program called Water Work. And Water Work is going to be engaging people, everyone that we can, in the comprehensive plan update to ensure that we have really good policies to ensure clean, plentiful water for future generations. So that's resources, that's me. And the Grange had some great questions, and I want to take the remainder of my time to address them. The first was just, I'll repeat them because you may not have been able to hear. The top 3 to 5 most important water resource issues for Whatcom County. I stuck with 3. There are a lot, and they're all very important, but I'm going to talk about 3 broad categories. We're primarily concerned with having enough water for fish and farms. Also, we're concerned that the water that we have is fishable, swimmable, and drinkable. And that no matter what choices we make as far as planning goes, that we choose a plan that protects water for future generations. Not just people, but animals too, everybody, so that we can live here for generations to come. So a little more detail on that. We think there should be enough water. I think you all think there should be enough water. And in-stream flows are a big problem that we just can't ignore, and nor is it wise for us to ignore them. We can't abandon fish for the sake of farms, no more than we could abandon farms for the sake of fish. So this is something that's really important, and we've got to figure out how to strike a balance. Clean water. We've made a ton of progress. I know, how many of you went to the first Rome Grange forum about this particular issue? Arms. Yeah, so you saw Carl Weimer's graph showing fecal coliform pollution in Portage Bay. And it was on the decline, and that's great. And the reason it's on the decline is because people really cared, they worked hard, they got some things accomplished, and that's great. We aren't the Whatcom County of the 1990s or 1980s anymore. We're making some good changes. But there's still problems, and we need to not rest on our laurels. We need to continue to improve our water quality. We need to stop fecal coliform. We need to prevent pesticides and metals coming in from stormwater, not just rural sources, but urban sources as well. So we need to be thinking about all these things. And then finally, that we have a sustainable resource, one that's capable of being continuing indefinitely. I know sustainability is kind of a buzzword and everyone uses it, and sometimes they use it really wrong. But in this case, what I mean is that something is sustainable if it allows us to meet our resource needs without compromising the ability of future generations to reach their resource needs. So we need to think when we develop a plan through this water action plan, which some of you may have heard about, or any planning effort that we undertake, that we need to think about that sustainability in that term, that we want a water resource that's good for future generations. So the next question was really about quantity. I mean, how do we provide an ample supply of water to people in Whatcom County? What's the right way to be fair about it, actually, I think, so as to be fair to all land uses? And I think this is a tough question because what's fair to one person doesn't feel fair to somebody else. And so I struggled with this one for a while, but you know, the truth is I gotta give some context. Right now we aren't meeting in-stream flow, so there's not enough water according to the standards set by the state in the streams to support fish. Basic, just not any extra information than what you need there. And so we only have a vague idea of how these surface waters are connected to groundwaters, and we need to know more information about that. And we don't really understand the extent of our groundwater system. We know the Sumas aquifer, but we don't know the extent of it and where it goes. And where I grew up in Eastern Washington, we knew our aquifer, we knew it well, we knew the parameters, we knew what vein our well was on versus what vein our neighbors were on. We need to get more educated about our groundwater system. So, you know, I guess to answer the question of what would be fair, the best system we have is the one we have, which is first in time, first in right. That's the best we can do. Until we come up with a solution that is more fair, whatever that may be, that's what we have. And if we're going to come up with another system, it has to be done together. We're going to have to work as a community to come up with a better system. It's not going to be, just private well owners and just tribes and just, you're not going to stand up the whole time? Okay. And just tribes or just the government coming down and telling you what to do. It has to be a community solution. We have to do it together. So the last question was about the pros and cons of resources approach versus the WID approach. And I'm going to tell you about the resources approach to the 10 Mile Creek Clean Water Project really quickly. Basically, it was about bringing the neighbors together in that community to come up with voluntary solutions to the fecal coliform problem occurring in 10 Mile Creek. None of these things are regulations. They're people, they're neighbors telling neighbors, hey, pull your cows back from the stream, or hey, you realize when you do that, it does this. It's neighbors working together. Is anyone on the 10 Mile Creek committee here tonight?
I was on the early
Oh,
access.
great. I think I saw one person, but maybe not. It's a great group, and those meetings are open to the public. You can go, and if you're interested, check out some stuff that I got at the back table there. I'm not an expert on WIDs. Am I done? Can I go just a little longer? Okay. I'm not an expert on WIDs, but I think it's great to have a taxing mechanism attached to this thing, because it means that if you identify a project that's important to the community, there's a funding mechanism to support it. One of the reasons that it's difficult to keep a project like the 10 Mile Creek project going is because there's no continuous source of funding for it. We had to get a private grant to do it. So those are some of the pros and cons of that. I also want to just put in a quick plug for Water Blues Green Solutions, which is a film that's coming to the Pickford Theater, co-sponsored by us, League of Women Voters, and Sustainable Connections. It'll be on May 19th, and there's a flyer at the back. Please come. Thank you.
Good job, Kate. The next speaker is going to be Mark Personius. Mark is the manager of the long-range planning for Whatcom County Planning Development Services. He will be responsible for managing the 2016 Comprehensive Plan Update and the 2016 Critical Areas Ordinance Update, and is involved in many related land use and water resource planning efforts for Whatcom County. Please welcome Mark Personius.
Thank you, George. Welcome, everybody. I want to just put out a shout out first to the Grange, to Larry, to Roger Olmskar and the group that has put this series together. It is so good that we are having forums like this, we're having conversations like this around the county in different neighborhoods and from different perspectives. That is such a healthy thing, that is such the right thing to do. We need to be sharing more of our ideas, our values, our differences, and most importantly, what we all can come to agreement on. So first I want to make a protest, like I file a protest, George, that we only get 8 minutes and Bob and Roger get 30. But I'll reserve that for later. So I will try to get through this as quick as I can. I've got just some points to hit on, and then hopefully we'll have time in the Q&A to maybe get into some more detail. The three most important water resource issues for Whatcom County, I put down resolution of the Nooksack Basin legal water rights status. Number 2 is improved surface water and stream quality, especially in rural and ag areas. And number 3 was Lake Whatcom drinking water quality. Let me talk just a little bit about each of those. In terms of the Nooksack Basin legal water rights status, I want everybody to know from the county's perspective that we are going to provide support and partner in the legal process by providing detailed scientific information and conducting or facilitating the research that needs to be done to inform the water quality and the water quantity needs. We, the county government, does not have a vested right. We don't have water rights but we do have a vested interest in the economic, the social, and the environmental impacts and outcomes of water allocation. So we know that we think we have a unique role here, which is very important to us, and we take it very seriously. There are issues that need to be resolved government to government. There are jurisdictional issues that need to be resolved about access to and utilization of our water resources. Part of that's going to be done through legal means, through court proceedings. Some of that will be done by negotiation and by coordination and cooperation. But we want to make sure that ultimately our goal is to make sure we've got adequate and legal access to water for all the users that need it in this county. And obviously there's a broad range of them. And that includes in-stream flows as well. Second issue is the water quality issue. We talk about agriculture. The ag census just came out. Ag is a $350 million industry in this county. It's a global industry. We export most of that, including overseas. It's something that we, certainly from a county government standpoint, are not in the business of trying to put out of business. So we very much know we need to facilitate the water use, including the legal water use and access to water for agriculture. We need to continue to communicate with small farmers and rural property owners on water quality issues. I know that's a huge challenge, I think, before us, is just how we talk about, not only how we talk about this, but how we communicate as a government with property owners. Ultimately, our goal is to get property owners to call what they call best management practices, or BMPs, so that the actions that we take on the land result in improved water quality. I would much rather, that is a much more efficient way to address that problem than it is for us to sit in the office and write regulations and then try to enforce it and send people out onto your properties and say, hey, you're not doing that right. We've been doing that for so many years, and we don't do a particularly good job of it. So I'll talk in a minute, hopefully, about some other ways we can do that better. And finally, and quickly, and I know this isn't necessarily a Lake Whatcom centric crowd, but making sure that there's adequate water quality in Lake Whatcom and addressing unique issues there is another concern of the counties, and we do spend a lot of effort, and we'll be spending resources on that. Okay, question number 2: how should an ample supply of water for long-term growth in both urban and rural areas be provided so as to be fair to all land uses? So I thought of 3 challenges here to answer that question. The first is that we don't have perfect knowledge, right, of the issues, the characteristics regarding water supply. We just don't have all the information that we need to make good decisions yet, much less fair decisions. We don't know how big the pie is. We don't know how we're going to divide that pie. There's some very fundamental questions. There's some scientific research that has to be done before we can answer that question. The second challenge is adversarial, political, and legal environment in which we currently discuss these issues, or at least the governments discuss these issues and the public discusses these issues. We all tend to get in our interest groups, we get in our silos, we harden up, sometimes we lawyer up. Sorry, Bob. And we need to figure out who's driving the bus, what's the roadmap for how we're going to get this done. And lastly, supply and demand management. Fairness, dictates that we look both at supply issues and supply challenges and supply potential solutions as much as we look at as equal as we look at that on the demand side. Okay, so let's talk about imperfect knowledge. I want to emphasize that the county's taken a 3-pronged approach at getting better information to keep this process moving along. First of that is we're preparing what's called the Coordinated Water System Plan, or the CWSP. It's a statutory requirement to address future need for public water systems. Those are municipal water systems, water associations, small public systems, Group A and Group B systems. This plan will look out 20 years project what the demand is going to be for water for those users. Okay. Status of that is that a consultant's been hired, and we're working on the scope and the budget as we speak. Second thing we're doing on that effort will be something akin to what's called a water supply plan. This is going to be a plan for other out-of-stream users, right? So this is going to be the farmers, industry, rural exempt well owners, those that aren't covered under the Coordinated Water System Plan by statute. That, we hope some of that, if we have enough budget and the budget season's coming up, if we have enough of that budget, we can start on some of that work as a part of the Coordinated Water System Plan. If we don't have enough budget, then that's going to be the very next thing we do after we do the Coordinated Water System Plan, okay? So that's going to address pretty much everybody's needs out here in terms of who's on the landscape using water right now, or who might do so in the future based on projected growth. And lastly, our emphasis right now is on developing a groundwater model and beginning to, as Kate talked about, one of the things we don't understand yet very well is the relationship between the groundwater and the surface water. Okay, we have a pretty good understanding of the surface water budget, but we don't have a good understanding of the groundwater budget. So we are issuing an RFQ, a request for qualifications for a consultant to help with that, to build a model. This is going to be focused first on the Abbotsford Sumas Aquifer, because we want to take a kind of a smaller piece of the Nooksack Basin, one we can focus on, and make sure that we can kind of come up with a model that can predict interaction or connectivity between surface water and groundwater, and try to figure out how much groundwater is down there, because that's just a missing piece of the puzzle we don't have yet. Where am I, George? Okay. Does that mean I have 1 minute? Thank you. Okay, just want to emphasize on the adversarial aspect of this, and you know, there's really two routes. There's a legal route, quantification, which is what the tribes have asked for. They've asked the feds to intervene and quantify their in-stream flow rights based on their treaty rights. And then there's what's called an adjudication process, which would be a state court process where the state, a judge, takes all this information and literally quantifies and ranks everybody's water rights. Pretty much says, here's who's most senior and here's who's most junior. The second alternative is to kind of what I call a do-it-yourself, or we figure it out ourselves. And I think what we're going to end up doing is probably some combination of both. But that understands that we have some kind of a plan that provides us public involvement, open decision-making. No one does not have a voice in that process. That's what the county wants to make sure of. We continue to provide good scientific information, so we have a good basis for reasoned, informed decision-making by the decision-makers, and to provide a framework that that decision-making process can be done with a full understanding of who does what, and as well as an efficient process for decision-making. I'll skip the supply and demand management stuff, and I will go very quickly since I'm going to take as much of Bob's time as I can. Last question on water quality is, what are the pros and cons of those two approaches, regulatory versus programmatic or non-regulatory? Well, I think they both have a role. I think we should do both, but I'd also like to introduce a third option. We have in our critical areas ordinance an option called community-based watershed management plans. And this was an idea that if you could develop a watershed management plan in coordination with the WIDS, with the Watershed Improvement District, you could come up with a plan for a much smaller area that you could use in lieu of the critical areas ordinance. In other words, instead of an absolute big down buffer that there's no variation from, you could work on, based on local land use practices and local land and water characteristics and local residents, come up with a plan for each of those watersheds or those subbasins. That's an option that we've got in the code, in the CAO. We're going to be starting the CAO update here next month, and that'll go on for about a year and a half. But that's something we'd like to introduce back into that process as well. That existing shotgun process hasn't worked so well on water quality, you know, the one size fits all. So we think that might have some promise for getting a little bit more local perspective on alternatives to kind of standard regulatory approach. And finally, there's also promise for incentive-based approaches, where a farmer might construct a wetland or enhance a wetland for habitat purposes, for habitat improvements, or for aquifer recharge purposes. And in exchange for that, or instead of a regulation telling him he had to do that, he could maybe get a streamlined ditch cleaning permit. And there would be, it's kind of it's called ecosystem services trading. It's an interesting approach. It's non-regulatory, but it's sort of emerging science, and so there's a whole, that's going to take time to work through those issues. But I just want you to know that we're always, trying to turn over rocks and find as many new ways to do things or better ways to do things as we can. So, thank you.
Mark, I just have to say, you set an exemplary example on how to respectfully object to an unfair process and make the most out of it when you do. Thank you for that. Our next two speakers, and they're going to tag team, are to begin with Roger Brown, and he served as a general manager at the Birch Bay Water and Sewer District since 1998, and as the Water District's caucus representative to the RIA 1 Planning Unit since 1999. In 2013, for Whatcom County Water Districts, Birch Bay Water and Sewer District, Columbia Valley Water District, Water District 13, and Glacier Water District entered into an interlocal agreement amongst themselves for the purposes of securing legal advice on water supply issues. Roger administers that agreement, and Bob Carmichael serves as the local counsel to that group. The Washington Association of Sewer and Water Districts is also supporting the effort. And while I'm at it, I'd like to introduce Robert Carmichael, and he's a full principal at Zender Thurston. He received his law degree at the University of Washington and his AB degree in the University of California at Berkeley, where he was inducted to Phi Beta Kappa. Mr. Carmichael began his career in Whatcom County Prosecutor's Office in 1984, spending 4 years in the criminal division and 4 years in the civil division before entering private practice in '92. He represents a wide variety of municipal and private clients in the areas of land use planning, permitting, municipal law, and water law. Please welcome our two next speakers.
How's this working? Can you hear me? Is this working? Okay. Thank you, George. We're going to talk about threatened litigation. It was mentioned that there are legal issues and process problems. I want to touch on the litigation that we're talking about arises in the context of certain process problems, and then finally some state-wide legal issues. In 1998, Puget Sound Chinook and other species were listed as threatened under the Endangered Species Act. When that happens, you have to have a recovery plan. The recovery plan goals, according to the National Marine Fisheries Service, are delisting of the species, number one. That's the actual requirement of ESA, and it applies to the wild fish. There's a second goal that pertains to the federal government's interpretation of their obligation to their trust responsibilities to the tribes, and that is to obtain a harvestable surplus of fish and restoration of meaningful tribal fishing rights. Wrong way. A locally driven process from a local watershed and citizen group perspective, developing a common vision and commitment and identifying regional recovery plans. A statement from the recovery plan itself: local communities are the essence of success, and local watershed efforts will lead the region to recovery. The state act that supported that, at least with respect to the water planning part of it, was the 1998 Watershed Planning Act, RCW 9082. It established a planning unit to direct planning. The scope of responsibility of the planning unit in WIRA 1 was extremely broad, comprising water quantity, habitat, water quality, and in-stream flows. And the process was to be open and inclusive. And that meant it included all of the local governments and a wide range of other interests, private well owners, water associations, and so on. I keep hitting that. Sorry, hitting the wrong arrow. The results were that the watershed plan was adopted in June of 2005, and it called for negotiations on in-stream flows involving the tribes and other parties. And the planning unit was to continue operating to receive those recommendations on in-stream flows and review them, to update the watershed management plan when needed, and to review legislative changes. The adopted plan had weight under the law. It was to be the framework for DOE's future watershed decisions, and required that DOE rely on that plan as its primary consideration in determining the public interest. There were problems, however, that arose. Stakeholders were excluded. We have contended that the council was placed in a secondary policy role. There was often lack of transparency in the process, and the Watershed Management Plan and a Watershed Planning Act were violated, so that the public interest was not actually being protected in the process. As a result of that, water districts and many other interests expressed concerns to the county executive and county council, and last year the planning unit was restored. There were actually no meetings for over 4 years. It's been funded now, at least for the moment, and work is underway. So with that, I will call on Bob to tell us about the law.
Thank you. I appreciate the opportunity to be here. Can everybody hear me okay?
Get closer.
Got to be closer. Maybe it's not.
Use the other mic right now, because we have that one off right now.
We're okay with this one now? Okay. Leave it to a lawyer to do something totally different and mess things up to start. So thank you for inviting me. In trying to put something together for you all, I was thinking about a metaphor, and the best one I could think of is I have 2 boys, and they both love to play baseball. They're older now, and I was their coach. We'd always be throwing things around. Whenever we'd go to a lake or a river, the first thing they want to do is skip stones and see who can skip the stone the most times along the lake or the river. And that's what I feel like I'm going to be doing today. This presentation is just sort of skipping along the surface of a number of really meaty topics. I'm going to try to go fairly quickly, and if you have any questions after we're done, I'm happy to stay as long as anybody wants to answer questions. So with that, and what I get to do now is ask Roger to do things. Usually he's asking me to do things for him. Now I get to ask him to run the presentation. So the first slide, Washington water law, just basically where things start from a legal perspective. To get a water right, you have to have demonstration of 4 things. There has to be beneficial use, non-impairment of other rights, that is senior water right holders. It has to be in the public interest, and the water has to be available. I'll come back to these concepts because they're pretty important in a lot of respects. The prior appropriation doctrine you're all familiar with, first in time, first in right with the water. And let's move on to the next slide. Wanted to start just with a brief summary of some of the tribal issues and tribal rights, because we do have 2 tribes in our area, and they are senior water right holders. So it's helpful to sort of understand what some of those rights are. There's 2 kinds of rights, I would say, just in terms of trying to categorize them. One consumptive and one non-consumptive. The consumptive right is what you'll often hear referred to as a winter's right, coming from a 1908 Supreme Court decision. And the concept behind that doctrine is that whenever there's a reservation by the federal government, either of an Indian reservation, a military reservation, a national park, you name it, that reservation impliedly has reserved sufficient water to fulfill the primary purposes of that reservation. Not the secondary purposes or the tertiary purposes, but the primary purposes of the reservation, and that's a quantity of water available for consumptive use. In the case of the Lummi Nation, there's been questions about what that is. Was that agriculture? Was that fishing? We've had some actual court decisions looking at that and that have leaned towards agricultural use. But getting into that kind of details beyond the scope of this presentation. The second type of use that the tribes have a right to is a non-consumptive use, and that would be an in-stream flow, which would be something necessary to support their fishery. Next slide. As many of you, if not most of you know, the Nooksack tribe and the Lummi Nation requested adjudication of their claims in federal court by letter to the Department of Interior. No action has been taken on that to date. Next slide, please. One of the key things to look at when trying to assess tribal rights is the basis for the right. Well, the basis for the tribal right is the treaty. And in the case of the Lummies and the Nooksacks, there's the Treaty of Point Elliott, which governs this area. And one of the provisions dealing with fishing gives them the right to take fish at usual and accustomed grounds. Next slide, please. Oh, I'm sorry, we're still going. That came out of the Bolt decision, and the area covered by the Bolt decision, which not a lot of people know. When looking at the Treaty of Point Elliott, you're looking at an area from Boundary Bay south to Fidalgo Bay. So we're not just talking about the Nooksack system, we're talking about a much broader area that would be governed by any decision affecting the Lummies' treaty rights or the Nooksack's treaty rights. These things will definitely require habitat. The fishing rights will require habitat, and there is no quantification as to in-stream flows in the treaties, but there would certainly be an argument for sufficient flows to support the fishery. Next slide. This slide and the next slide is intended to mention something about the Bolt decision that not everybody knows, and this is something that came after the actual district court decision. It actually went up to the Court of Appeals and ultimately to the United States Supreme Court. And one of the features of the decision was that the court said that the 50% right to the catch, which most people know the Indians were awarded, is not a it's a maximum, I'm sorry, it is a maximum allocation, it's not a minimum allocation. Which means that things could change, and if there are changed circumstances in terms of the tribal needs, that right theoretically could be reduced from 50% to something less than 50%. What the tribe is entitled to is no more than what is necessary to provide the Indians with a livelihood, that is to say, a moderate living. And again, if things change, those rights could change. This is definitely an issue that would come up in any adjudication of tribal rights as to what their real needs are at this point in time. The next slide, please. There's another reference to a quote from the same case that basically says something similar, that the 50% is a maximum, not a minimum, that could change based on circumstances over time. Next slide, please. In the petition to the Department of Interior, and also in a court case that occurred in the early 2000s on the Lummi Indian Peninsula, the tribes, the Lummi tribe in particular, raised this notion of a homeland right. And that is an interpretation of their treaty rights that exceeds what the Ninth Circuit has in the past granted. In the past, the Ninth Circuit has, as I mentioned, and the Supreme Court for that matter, indicated that reservation rights are limited to primary purposes of the reservation, not secondary or other purposes. The tribe made the claim that they have a homeland right, meaning a right for as much water as they need to make use of the reservation for a homeland. Over time, their needs could change. It's something that was reviewed by Judge Zilli in the Western District Court, and he came to the conclusion, which Roger put at the bottom in bold just now. He concluded that it was like a water right for a broad and almost unlimited range of activities. Now, this right was recognized by the Supreme Court of Arizona in a decision called the Gila River decision. It's a much more expansive right than has been recognized in the Ninth Circuit or other Western states. But I would expect in any adjudication this will be a claim made and that it will be an issue to be decided by the court. Next slide, please. The homeland concept includes an in-stream flow right, and both the Lummis and Nooksacks assert an in-stream flow right separate from the homeland right. Next slide. What are some of the potential effects of these claims? Well, first, because the tribal rights date from the date of the treaty or before, in the case of time immemorial rights, they're going to have the senior rights. Existing rights may be reduced as a result of those, or even extinguished depending on the extent of the claim. And it could result in restrictions with potential effects on surface water, groundwater, and water delivered by contract. And the effects are potentially, well, they would be permanent after an adjudication, if we get to an adjudication, which at some point there will have to be some resolution of these issues, whether it's 2 years from now, 10 years from now. Your guess is as good as mine. Next slide, please. So the impacts of the decision are over, or of any court decision that's potentially coming out of this would be over a broad area beyond the Nooksack Basin, because again, remember the Treaty of Point Elliott extends from Boundary Bay to Fidalgo Bay. These tribes are party to the Treaty of Point Elliott. Next slide, please. The thing a lot of people don't know is that in a little over a month, there were 3 other treaties signed with Indians in Western Washington. The Treaty of Medicine Creek, followed by Point Elliott, followed by Point No Point, followed by the Treaty of Neah Bay. Governor Isaac Stevens was the one spearheading that. He was busy getting all these treaties signed. They all had very, very similar language. And so these issues are not just Boundary Bay to Fidalgo Bay issues. Actually, they're Western Washington issues. If you look at this map, the purple shaded area is the area covered by the Treaty of Point Elliott. The area below that is the Treaty of Medicine Creek. The area that's green that's being pointed to by Roger right now is Point No Point, and the one over on the far west peninsula is Nia Bay. So you can see just by looking at the map, that's a good portion of western Washington. If it comes to an adjudication and the rights of the tribes are being decided, that it would have a huge impact not just on Whatcom County, but much of the state. Next slide, please. Some people, I think most people know this, but perhaps you don't. Water rights can only be given legal certainty through an adjudication. Department of Ecology is not a decision maker on water rights. They do make decisions that affect water rights, but they do not actually decide water rights. That's a decision made in court, and in court only, unless it's through some other resolution of the parties. And an adjudication that covers the water rights of all users in a given area is called a general adjudication. It's a formal process, due process. The courts will oversee it, and they will also encourage the parties to discuss settlement in those contexts. And ultimately, if there is no settlement, there will be a decision. Now, an adjudication can take place in either federal or state court. The Lummies and Nooksacks have requested adjudication in federal court. That doesn't mean that it will necessarily happen in federal court if and when it happens. Go to the next slide, please. There is a piece of congressional legislation from the 1950s called the McCarran Amendment. So it's a United States law passed by Congress, which gave up sovereign immunity in water right adjudications. And what that means is the tribes and any other federal reservation does not have the right to insist on adjudication in federal court. Now, it may still happen in federal court. The federal court has jurisdiction, but they don't have the right to be in federal court. It can be in state court, any adjudication involving tribal rights. An example of how that played out in our state would be in the Aquavella case, which was Yakima. That originally started in federal court. The state filed a general adjudication petition, and ultimately that case got remanded into state court, and it was handled in the state court system, not in the federal court system. Next slide, please. We'll skip this one. Oh, no, I get the only point of this one is to say that one of the reasons for the McCarran Amendment was to avoid piecemeal litigation, so that if there was a general adjudication occurring in state court, the preference was to have all the right holders have their rights decided at one place and one time, rather than have it decided piecemeal, potentially in federal court here, state court there. And so there's some level of preference for state court. Next slide, please. So I've talked a lot about general adjudication. Nobody wants to go to court. Nobody likes to go to court. As a lawyer, I even think it's a bad idea most of the time. But, there really is only one place to resolve water rights, though, and that is in court. The problem is we're not ready. The state isn't ready. The county isn't ready, in my opinion, for an adjudication of water rights. There's just not enough information. As you know, if I were to be representing somebody who had an interest, I would say, look, we've got a lot of information to gather here. We've got a lot of things we don't know. You heard from a number of your earlier speakers about all the efforts on information gathering, and really there needs to be a lot more. So what are the steps towards solution? One, again, in my opinion, is ESA compliance. I think that given the fact that the tribes have an in-stream flow right of some degree, we don't know what it is because it hasn't been quantified yet. We don't know whether it's a lot or a little. We do know that ESA has to be complied with. And we do know that there are endangered or threatened species that swim in the waters around here. And ESA says you can't take those fish. meaning if one of them dies, there's a take. One way around that is through the development of what's called a habitat conservation plan. You can take a fish can die if it's pursuant to an approved habitat conservation plan where the species is really being taken care of. My former partner, Dan Zender, who's no longer with us, did the first habitat conservation plan in the entire United States in the 1990s. Got it approved, had his picture taken with Al Gore. It was during the Clinton administration. And I know that having worked with him that they're not undertaken lightly, they're expensive, they take time. But frankly, it may be long-term the best solution for the communities. Secondly, full implementation of the Water Resources Protection Act. I'm going to talk about that next because Habitat Conservation Plan and ESA compliance is too big of a topic. I'd be going way over my time, which I'm already probably going over. So I want to talk about implementation of the Water Resources Protection Act, which is a state law, and 3 new minimum in-stream flows established by rule as potential solutions to work towards. Next slide, please. So what does the Water Resources Protection Act say? This is really important. This is one of the fundamental purposes of the Act. In fact, it says it is the purpose of this chapter to set forth fundamentals of water resource policy for the state to ensure that waters of the state are protected and fully utilized for the greatest benefit to the people of the state of Washington. Next slide. The objectives have also been identified by the legislature in an amendment to the Act later, where they said provide sufficient water for residential, commercial, industrial needs, provide sufficient water for productive fish populations, and provide sufficient water for productive agriculture. All great objectives. Next slide. I've identified, this is my take on it. Again, somebody else may have a different take, but for purposes of trying to winnow this down, I've identified 4 key values from that act, again, which is a fundamental act passed by the legislature. 1, achieve maximum net benefits. I'm going to talk some more about that. You may not have heard of that concept, but it's a really important concept. 2, protect base flows. 3, preserve and protect adequate and safe supplies of potable water to satisfy human domestic needs. 4, expressions of the public interest will be sought at all stages of water planning and allocation discussions. One of the really useful things to take away from this, if you take away nothing else, is each of these concepts is on parity with each other in the Act. One isn't given priority over another. In other words, protecting base flows does not have priority over preserving and protecting adequate and safe supplies of potable water for human consumption, or with achieving maximum net benefits. They're all equal. Next slide, please. So what are maximum net benefits? Allocation of waters among potential users is intended to ensure the maximum net benefits for the people of the state. Next slide. This is in the Water Code, outside of the Water Protection Act. Even in the Water Code, it recognizes maximum net benefits as arising from both the diversionary uses of the state's public waters and the retention of waters within streams and lakes in sufficient quantity to protect in-stream and natural values and rights. So it's a balance of both. We got to have enough water for people and for fish. These are the interests that are identified in the Water Resource Protection Act that have to be balanced to achieve maximum net benefits. It's a long list. You can read it. It includes basically everything. In-stream flow rules. This is the section on in-stream flow rules. It says that the quality of the natural environment shall be protected and, where possible, enhanced. There are in-stream flow rules that have been adopted in a number of different WIRAs, and they're in those sections of the Washington Administrative Code. Next slide. MIF stands for minimum in-stream flow, in case you're wondering. At the time most in-stream flow rules were established, groundwater was thought to be separate from surface water, and it was assumed out-of-stream needs could be met with groundwater. This was back in the 1980s when this was done. Next slide. As a result of that assumption, the maximum net benefit analysis didn't take place through the Department of Ecology. But by the early 90s, it was realized that there was this significant connection between groundwater and surface water through advances in the studies. In-stream flow methodology, in most cases in our state, is based on a percentage of exceedance. And this is really important. I'm going to ask you to bear with me if I go over time. There's a few slides I want to get to. The exceedance means that it was set at a level so that 50% of the time, for example, 50% of the time the in-stream flow historically, the historic in-stream flows would be exceeded, and 50% of the time they wouldn't be met. If it was set at 80%, then 20% of the time it wouldn't be satisfied, 80% of the time it would be met. Next slide, please. In our area, it was a 50% exceedance. So in 1985, when the minimum in-stream flows were set for all the streams and rivers in this area, they were set at a level, and knowingly set at this level and purposely set at this level so that 50% of the time they wouldn't be met. And 50% of the time they would be met based on historic flows, and that's how they set the levels. Next slide. So as a result of that methodology, which you can imagine there's some problems with it. I mean, a lot of times you hear, oh, in-stream flows aren't being met. That's a big problem. Well, they're not met. They weren't ever set to be met. And that's something that's important, I think, for people to know. So de facto groundwater closures, most of the Nooksack system is closed to uninterruptible appropriations. There is questionable legal authority for those closures for a number of reasons. Not just because of the in-stream flow rule, but also under sections of the groundwater code. It's pretty clear you have to take permits and process them. There's nothing in the statute that actually says you can have a closure. It's based on WACs, administrative code rules. Next slide, please. So DOE's typical approach had been to reserve water for out-of-stream uses under the OCPI, or Overriding Considerations of Public Interest provision. That's how they dealt with the shortages for a long time. Once the continuity between groundwater and surface water was established in the 90s, now that's no longer possible under the recent Swinomish case. Next slide, please. So under the Swinomish decision, these are some of the principles. In-stream flow rules are water rights. They can't be impaired by later appropriations. Ecology can't use OCPI, Overriding Consideration of Public Interest, to amend in-stream flows. And go to the next slide, please. So what are some of the problems with the minimum in-stream flow rules the way they stand now? One, we really never had a maximum net benefit balancing analysis. Remember all the different uses that were there. That should have been done. Failure to protect adequate and safe supplies of potable water to satisfy human needs. Well, if you're going to start talking about cutting people off from domestic supply, then you're violating that provision of the Water Resource Protection Act. And then 3, not satisfying the 4-part test for water appropriation. I need to explain this one. Go to the next slide. Did you skip one? Or is that? Okay, so the intent of the minimum in-stream flow of the Water Resource Protection Act was to set base flows that were base flows. According to this author, they were designed to be the smallest amount reasonably necessary to protect the values. The author of this is a real property desk book statement or quote, was the the main water rights attorney for Department of Ecology when the Water Resource Protection Act was written. And he's written that it was meant to be base flows and then, which means basically more than a trickle. Next slide. The base flows are things that have to be set, and then according to this quote from the same source, once that's done, then you do the second step of maximum benefit analysis, and you balance out what's left, what you need for fish and wildlife, what you need for people, what you need for agriculture. So you do have to set that minimum base flow, but having a default at 50% of historic flows up or down was never mentioned. Next slide, please. So again, the maximum net benefit analysis is based on securing the maximum net benefits for the people of the state. That has not been done. The effect has been essentially to elevate minimum in-stream flows over other uses. It's not to say minimum in-stream flows aren't important. They are protected under the law. It's just that there's other uses too that are protected that you don't often hear about. Next slide. That's one of them, the adequate and safe supplies of water. Next slide, please. So what's one of the biggest problems? This is what I wanted to get to with the in-stream flow rule, the way it was set at the 50% level. So it's always going to be in failure 50% of the time. We now know, well, we've known under statute and under 2 Supreme Court cases that, number one, once established, a minimum flow constitutes an appropriation with a priority date as of the effective date of the rule establishing the minimum flow. 2, as appropriations of water, minimum in-stream flow must meet the same requirements as any appropriation of water under the Water Code. That's not me talking, that's the Supreme Court in 2 separate cases, including the Snohomish case. And number 3, under the statute, the same thing, minimum flows shall constitute appropriations. Next slide. So what's the test? This is going full circle now back to the beginning of the presentation when I said, what are the 4-part tests for a water appropriation? And again, minimum in-stream flows are a water appropriation. 1, the water has to be available. Well, was the water available if it was not being met 50% of the time when it was set? It seems like a logical fallacy. And then the other one that's questionable is number 4, no detriment to public welfare. Next slide. That's basically what we're saying here. What are some opportunities? Engage in the public maximum net benefit analysis for all uses as required. This has to be done in a public forum. Protect and preserve human and domestic needs. Amend in-stream flow rules. Do it correctly through a public process. It has to be done publicly. The statute says that the public has to be involved throughout the whole process, and it's critical that it be done that way to comply. That is it for what I had to say.
There's more, George.
Well, we've exhausted the time, so let's take a little break and
Okay.
we'll talk about that on the side.
There are some extra copies of the presentation back there that have one.
Right, so let's take about a 3-minute break. Stretch your legs. If you need to go to the washroom, let's do that, and then we'll reconvene here in 3 minutes.